Good afternoon and welcome to the Committee for Justice's virtual panel discussion, Protecting Voters' Rights Against Vote-by-Mail Mandates. I am your host, Ashley Baker, and I'm Director of Public Policy at the Committee for Justice. I'm now going to introduce the panelists in the order in which they will be presenting. Catherine Engelbrecht is a mother, native Texan, activist, technology entrepreneur, and lifelong practitioner of common sense. In 2009, she founded True the Vote, now the nation's leading voters' rights organization. True the Vote empowers organizations and individuals across the country to actively protect the rights of legitimate voters, regardless of their political party affiliation. As a recognized spokesperson on voters' rights and free speech, Catherine has appeared on television and talk radio, testified before federal and state legislatures, and spoken to grassroots activists across the country. National honors include the CPAC Ronald Reagan Award, the Horowitz Foundation Annie Taylor Award, the Breitbart Stanwith Award, along with dozens of state and local commendations. A graduate of the University of Houston, Catherine lives on her farm in Cat Spring, Texas, with her two children, William and Elizabeth. James Bopp Jr. is founder of the Bopp Law Firm. In January 1973, the United States Supreme Court issued its notorious Roe v. Wade decision, which legalized abortion in our country. That same year, Mr. James Bopp of the Bopp Law Firm, a native of Indiana, began a legal career which earned him the title of Conservative Titan from the Washington Times. With a law degree from the University of Florida and a bachelor's from Indiana University, Mr. Bopp has crisscrossed the nation, working on more than 180 cases in state and federal courts. He has earned a reputation for knocking down laws which he believes inhibit the expression of free speech in political campaigns by citizens, candidates, issue-advocacy groups, and corporations. He has won 9 of 14 cases in the United States Supreme Court, including the landmark ruling in 2010, Citizens United versus Federal Election Commission. Mr. Bopp has earned several awards during his 47-year legal career, including recognition in 2013 by the National Law Journal as one of the 100 most influential lawyers in America. In 2005, Legalized International honored him with the John Cardinal O'Connor Pro-Life Hall of Fame Award. Among the many positions he has held, Mr. Bopp serves as General Counsel for National Right to Life Committee, General Counsel for the American Federation for Children, General Counsel for True the Vote, and Special Counsel for Strategic and Campaign Finance Law Advice to the Trump presidential campaign. His extensive political activities include serving as Vice Chairman of the RNC. Jason Snead is the Executive Director of the Honest Elections Project. Prior to heading the project, Jason spent 10 years at the Heritage Foundation, where he had the honor to work for former Attorney General Ed Meese. During his tenure at Heritage, Jason rose to become a senior policy analyst and a recognized expert on a wide range of subjects. He regularly studied, wrote, and spoke on topics ranging from criminal justice and civil asset forfeiture reform to technology policy and the regulation of drones in American skies to preserving the integrity of American elections. Jason also managed the development of the Heritage Election Fraud Database, a unique tool aggregating proven instances of voter fraud from across the nation. Jason holds a master's degree in public policy from George Mason University's School of Policy and Government and a bachelor's degree from Bowling State University. So the brief presentations for our panelists will be followed by a discussion segment with myself and the three panelists in which we're going to kind of discuss this issue more broadly. That's going to be a bit more conversational, and then we're also going to have Q&A after that. What I'm going to do for Q&A is the Q&A function in Zoom is open. You can start sending me your questions at any point throughout the webinar, and then I can ask them as we get to the end. So if you'd like to go ahead and send questions in at any point, feel free to go ahead and do so. Catherine, the floor is yours.
Thanks very much, and thanks for the invitation to participate. As an activist and not an attorney, I have a unique perspective, I think, on what we're seeing unfold across the country, where we are watching as the Democrats and radicalized special interest groups are using this fog of COVID to fundamentally remake American elections. And, you know, everybody from Eric Holder to Mark Elias have said as much. They are intentionally using this crisis to change election laws in ways that would serve their purposes. And so the way that that's manifesting is to date, and Jim may correct me on this, but I think there's approximately 15 cases in play right now across the country where they're pushing to change election laws. That doesn't include the executive orders that we've seen be passed, like in New York, or the administrative fiats that we've seen in Nevada. It is a full court press to do everything possible to remake the process in a way that will cause absolute, and what I would argue is engineered chaos. So how did we get here? There's some backstory that needs to be told to put into focus why it is that universal mail-in ballots now present such an incredible threat to election integrity. You know, you read the polls and it would indicate that you know, across both sides of the aisle, the idea of mail-in ballots is favored. Okay, well, you know what, that's convenient, and certainly in this time of the pandemic, we should be able to mail in our ballots. But what that leaves out of the discussion is the reality that comes with mailing a ballot, how that ballot finds its way to your mailbox, how it finds its way back to the county office, all of the lack of fraud prevention that is surrounding it. People don't understand that, and it's important that we get a handle on it and explain it, so that before we all toss in on mail-ins, we really understand the underpinnings and how shaky they are. Two things I want to point out that I think have worsened the problem. The first is the Democrats have fought tooth and nail to, first of all, bloat the registration rolls. And we all remember the Acorn scandal, and you know, when Acorn was disbanded, it just scattered, and now you have hundreds of groups that are paid to turn in voter registration applications, and they just do this like a mill. So what you end up with is a lot of what we call deadwood in the voter registry. That is not routinely removed. And so you end up, again, with bloated rolls that aren't being cleaned. And for any state that might decide that they do want to take a stab at data maintenance, they'll find themselves in a lawsuit where these same leftist groups will come in and sue to prevent the cleaning of these voter rolls. They're also suing to, as we all know, suing to prevent voter ID. So two fundamental pieces, good data and a way to verify, are absolutely antithetical to what the Democrats want to do. Now introduce universal mail-in ballots. It's a perfect storm to make sure that people, inactive voters, people who've long since moved, people who may have died, people who are registered more than once, people who don't even exist, all of all the junk that's in the registry gets mailed straight out to everybody on the list. And that's what we're fighting against. And so the reason I'm on this call today is that we have launched an initiative called the Voters' Rights Initiative, and we are represented by our general counsel, Jim Bopp. I got a call several weeks ago now from a True the Vote volunteer in New Mexico who was panicked that there was a court order that was flying through, a petition that was flying through uncontested, that would have taken the whole state into a universal mail-in ballot position. And so I picked up the phone and called Jim and said, what can we do? This is just the beginning of the long war. And we jumped in, and Jim, I'll pitch it to you to tell the rest of that story.
Well, we did jump in right away, and you know, it was over in like 8 or 10 days, but and what we attempted to do was intervene in the case on behalf of voters, because the fundamental point here with respect to the efforts of the Democrats to legalize universal mail-in balloting or radically expand absentee balloting is that it strips away fraud protections. And those fraud protections mean there'll be more fraud in the election, and therefore the legitimate, the eligible and registered and legitimate voters' vote will be diluted with these additional illegal ballots. So the voters' right to vote is being violated when these fraud protections are being stripped away. Now, of course, then they went for their nirvana. in New Mexico. They wanted universal mail-in balloting. Now, understand what that means is, you know, compared with traditional absentee, to get an absentee ballot, there are two things. One, you have to apply to get the absentee ballot, which means, and contemporaneously in most states, which means you actually exist, you can give your current address, and there's a time frame that election officials or candidate representatives can investigate whether or not this is a bona fide voter. So the absentee is and often there are a whole bunch of fraud protections that surround the application process. So it's a great way of making sure that only eligible registered voters actually get a ballot. Well, the Democrats in universal mail-in balloting is they just eliminate the application. And they go to the voter rolls, these bloated voter rolls, and mail everybody a ballot without an application. And so that one really very big fraud protection is what they certainly are challenging initially. They want to, they don't want to have people to have to apply, and the other associated fraud protections that ensure it's a legitimate ballot. Now, Jason will talk about how if they get universal mail-in balloting, or if they get no excuse absentee, which they are also trying to get, that they also want to strip away other protections. Now, no excuse absentee means in most states, you know, you have to apply to get the ballot and all that, but you have to have a reason. In other words, you have to be disabled or over 65, out of the country, and on election day. In other words, there's traditional reasons that most states have to get an absentee ballot. Well, they are attacking those. And we've had a state court judge in Texas rule that because of COVID-19, every single person in the state of Texas is currently disabled. Of course, they're not, but they're because of the fear of COVID-19. So they, and then we've had another group come in and all now saying that the restriction of you have to be 65 or over to get a absentee ballot is also unconstitutional, which means if you take out the 65, well, then that means everybody can get an absentee ballot, and that excuse would become a non-excuse. So that's their game plan. Now, Catherine has already explained how that increases fraud from a practical standpoint because of the bad rolls. But of course, in the current context, if you suddenly, as in Wisconsin, have instead of 250,000 absentees, you have 1.1 million absentees. Look, the polling places aren't ready for this. They don't have the staff or the funding. And so these other fraud protections will just be ignored. And they have flooded the chaos that they have created will ensure massive fraud. Well, that's the nirvana they were looking for in New Mexico. Our intervention on behalf of voters was denied, but we filed an amicus brief, and I've never really had this experience before. I filed many amicus briefs, but the first 45 minutes of the oral argument in the New Mexico Supreme Court was all about True the Votes, amicus brief, and the arguments that were made in it. And surprisingly, the 5 judges backed off and unanimously said, no, we're not going to overturn state law and order ballots to be sent to every person in New Mexico. So it's a matter of voter rights that, and for you lawyers, you can read Reynolds versus Sims, the 1964 decision, you know, the wellspring of this, where they recognized a right to vote that was protected by the US Constitution and said that that right to vote can be violated in 2 ways, not 1, 2. One is to prevent somebody from voting. And of course, that's the one we hear about all the time and the only one the Democrats ever talk about. And of course, we don't want anyone to be unjustly denied the right to vote. So if you are, you can sue, your right to vote is being violated, and you can stop it. But they also said equally is a violation of the right to vote is ballot stuffing. And they use those words, ballot stuffing. And that is because of vote dilution. That is, my vote is being diluted by ballot stuffing. That is, unlawful votes being cast. That is an equal violation of the right to vote. Democrats never talk about this one because ballot stuffing is exactly what they're all about and is their plan through the scheme that they are now implementing. And in my view, we're at the end game. Now, often this is being done by court cases or by bureaucratic fiat. And in either event, those can be a challenge, or voters can intervene in court cases where they're trying to get judges to do it. Now, let me tell you one other interesting claim that could also be made. And that is the time, place, and manner clause of the US Constitution. And of course, manner is the voting procedures and polling places and all that, shall be prescribed in each state by the legislature thereof. So it's the legislature, not bureaucrats, not the governor, not the courts, that must establish election procedures, or it's unconstitutional. And of course, we have multiple efforts around the country to do this. Now, there are suits being filed every day throughout the country. By 15, I showed Catherine was a week or so ago. I'm sure we're up to 25 or 30 by now. And it's going to cascade all year long. This requires a huge effort. We have got to prevent them from remaking our elections as they have planned for decades. Bloated rolls, send them all a ballot, have no fraud protections. We're done, and democracy is done, and there's no faith in our elections. So Jason will tell you about even more of the fun thing. Not satisfied with getting, universal mail-in balloting, there's still a few fraud protections they want to get rid of, right, Jason?
Yes, unfortunately, that's the case. So, this has been a fantastic overview so far of how we've got to where we are, and I want to take a few moments to talk about what the immediate tactical objectives of the left seem to be when it comes to getting rid of whatever protections there are in place right now on absentee ballots. And I believe that the immediate goal is, as we've heard, to get as many ballots into the hands of voters as possible, whether or not those voters are real, whether or not those voters intend to vote. And to the fact that these ballots are going to be sent to voters and be voted away from the controlled environments of polling places opens up the opportunity for either fraud or for coercion or intimidation of voters. And that's why we have laws and procedures in place to protect absentee voters as much as possible, given the inherent vulnerabilities in that form of voting. But what we've seen from the left is a willingness to challenge any law, any rule, any practice, no matter how unobjectionable it may be, and no matter the consequence to the integrity of the overall process, if it presents even the slightest friction for their ground game this November in terms of getting out the vote from their constituents. And so because that ground game looks a little bit different state from state, one of the things that we've noticed as we've watched these legal arguments and legal cases be brought up is that both the arguments and the public messaging will shift, and sometimes shift a full 180 degrees basically overnight. For comparison, look at how Mark Elias, who is a partner at Perkins Coie, he's the Democrats' lead election lawyer. He characterized the election in Wisconsin as a travesty, that requiring any Wisconsin voters to go to the polls in the middle of a pandemic was tantamount to murder. But just a few days later, that same lawyer was filing a case in Nevada challenging that state's closure of in-person polling places and a move towards an all-mail vote, saying that that too was a travesty. So you see that they're willing to say just about anything in these court cases. It's all about the immediate end goal, which is to maximize their own political advantage in either the elections that are still remaining this year, running up into November, or the November election itself. And that Nevada case that I mentioned, which is actually, if you can believe it, called Corona v. Sigofsky. I got to give credit where credit is due for finding a plaintiff whose name is Corona. But nevertheless, that suit is really a perfect example of the boldness and the sheer audacity of what the Democratic Party and its allied organizations are asking for in these voting rights cases. This case challenges recent rules that were put in place by the Secretary of State, which ultimately is trying to move Nevada's upcoming election to an all-mail election. But right now, what the Democrats are suing for in that case is the undoing of essentially every ballot protection in place right now. They are asking for ballots to be sent to every inactive voter. The current proposal is to send ballots only to active voters, which still presents serious problems, but they want ballots sent to every inactive voter as well. And they want to establish that no absentee ballots can be rejected for things like signature mismatch. So that suit is actually arguing that, first of all, excluding inactive voters from the automatic mailing process is an undue burden on the right to vote and is therefore unconstitutional. They make that same argument as well as First Amendment free speech claims when they challenge the state's ballot harvesting ban. So they want to legalize ballot harvesting. And they say, again, that it is voter disenfranchisement if a ballot is rejected because the signature on the ballot does not match. So what we see is sort of a 1, 2, 3 there, where we are trying to get rid of any protections, even in the all-mail vote context, such as not sending ballots to people who are not active voters. Secondly, we see the attempt to legalize ballot harvesting, which exposes voters to coercion or intimidation in their own homes, away from any protections that might exist in a polling place. And third, that any absentee ballot that is received should be counted, even if it can be demonstrated that it is fraudulent. So that is where we are right now. And I think that case perfectly exemplifies just how audacious their efforts are in removing the protections that we have in place, in addition to calling for an all-mail election. And so I don't think that at this point it's anything close to hyperbole to suggest that the left, whether it's the Democratic Party itself as a plaintiff or whether it's an allied organization, is going to, or in fact may already be, challenging literally any practice or procedure that provides even a modicum of security to the electoral process. They will challenge these rules as unconstitutional burdens on voting. And there are, as Jim said, probably more than 24 cases at this point that are active, and we're seeing 2 or 3 new cases being brought a day sometimes. In fact, there were 2 cases yesterday. Unfortunately, this pace is likely to continue because the pandemic has created new opportunities, not only to revive old fights. We saw this in Wisconsin when the challengers in that case used the opportunity to take another swing at the Wisconsin voter ID law, which has been upheld time and time again, but also to push new fights in the election space. And so I just want to walk through some of the clear priorities that we're seeing in these cases so that everyone can understand exactly what it is that they're looking for. So the first is ballot harvesting. We saw in the Nevada case that the Democrats there are pushing for legalized ballot harvesting, and they're pushing that in other cases as well. And they've had some significant wins to date. In Minnesota, just yesterday, there was a consent decree announced where the state's Attorney General, Keith Ellison, unsurprisingly decided to settle a challenge to the state's ballot harvesting ban. So as of now, in Minnesota, ballot harvesting will be permitted in future elections, as well as candidates themselves actually helping people cast ballots. It should not take a great deal of discussion to see the potential problems there, the conflicts of interest that could arise, but nevertheless, that is the case now. There was also a significant win in Arizona, where the state's out-of-precinct polling law and ballot harvesting ban were both challenged, and in the Ninth Circuit, those laws were struck down. But fortunately, the state of Arizona is seeking Supreme Court review, and so there's an opportunity there for anyone looking to provide amicus support to file a brief. The cert stage briefs are due, I believe, on the 27th of May in that case, and that is a tremendously important case in terms of protecting our elections against ballot harvesting. On the absentee ballot front, we're seeing that any sort of absentee ballot protections are also vulnerable to challenges from the left. This includes ballot witness requirements. There's a case ongoing here in Virginia, League of Women Voters, against the state board of elections, trying to invalidate the requirement that absentee voters have witnesses. And again, this is a basic protection to ensure that the ballot that you are receiving, and as a polling official, has actually been voted by the person who is supposed to have voted that particular ballot. That is one of the protections which is absolutely necessary because the voter rolls are in such poor shape. But in Virginia, that law has been challenged. The similar requirements were challenged in Wisconsin. A case in Oklahoma is ongoing where notary requirements are being challenged as well. So you can see a systematic attack on essentially every sort of voter identification requirement in the absentee balloting context. Similarly, with signature match requirements, those laws have been challenged in Florida, Michigan, and elsewhere. And voter identification requirements more broadly are also being challenged. So what we're looking at right now is a large and growing landscape of cases that are attempting either to force all-mail elections, or if all-mail elections are provided for, to undo in systematic fashion essentially every protection that is afforded to voters, to prevent them from being the victims of intimidation or coercion, to ensure that they have confidence that their ballots are being properly cast and counted. And that's a very serious problem for the credibility of our elections, not only for this cycle, but for future election cycles as well, because there is obviously a great deal of interest on the left for undoing all of these protections on a permanent basis. And this is an incredibly important issue that needs to be confronted right now. Thank you.
Great. Thank you, Jason. We're going to move into the discussion portion now, after which we have quite a few questions in queue right now. We're actually probably not going to get a chance to get through them all. But let's, kind of looking at the broader picture, the election is 6 months from now, which is one of the reasons why this is ridiculous to begin with, is we don't know what situation we're going to be in then. It's very, very premature to say the least. Where could this move through the courts potentially? Do you see this, going to the courts of appeals? Like, what does the litigation landscape potentially kind of look like over the next few months?
Well, we're currently involved. We were involved as an amicus in the New Mexico Supreme Court on behalf of True the Vote's voter rights initiative. But we filed suit on behalf of voters in Nevada to challenge the Secretary of State's decision to authorize every single precinct in the state to be universal mail-in, circumventing their in-person voting and absentee ballot procedures. So we are suing there. We moved to intervene in the state case that Jason mentioned, and we also moved to intervene in the Virginia case that he mentioned. Fortunately, the Republican Party has been active. We have seen them intervene in several of these cases. I guess they missed Minnesota, which is very unfortunate. And this idea of consent decrees is spreading. In Virginia state case that we moved to intervene in, while our intervention request was pending, the Democrat state officials that have been sued by the League of Women Voters came up with a consent decree to invalidate the legislature's witness requirement when you submit an absentee ballot. Now, that has not yet been approved, and while our intervention was not granted, the intervention of the state Republican Party was. And I tell you, just litigating this for just a couple of weeks has, as we have explained, exposed the real dangers that we are in treacherous waters we are involved here. And I can assure you that through the voter rights initiative is seriously considering lawsuits in other states where this has been legalized by the governor of New York, or by election board in Indiana, or by a governor in Kentucky. There's unfortunately too many examples of this. We have got, and of course, Honest Elections has been great about filing amicus briefs. I think they have done so in eight or so cases by now, maybe 10, which has been very helpful. A comprehensive legal approach needs to be, if we just let them collude together in a lawsuit in a state, or a lawsuit in federal court, you can just be assured that they're going to roll over, and we have to vigorously fight these. And if we don't, it'll be game over.
Yeah, so one of the questions from the Q&A actually ties in pretty directly to where you left off regarding the states. This might be more of a question for both Jim and Catherine. And the question is, how have the states that currently have all mail-in ballots deal with the concerns, both practical and legal, that you've raised?
Do you want to go, Catherine?
Sure. Well, yeah, I'll speak to the practical part of it. True the vote is focused. The litigation thing is an absolute necessity, but our truth and sort of long-standing focus has been training volunteers to work inside of the polls, to work in absentee ballot review boards, or mail-in ballot review boards, as it now seems like it's going to become. And so I've spent a lot of time talking to folks about what their experience is, and I'll tell you, they're terrified. They are absolutely paralyzed by the thought that what they've been doing, I mean, 2016 was already a huge turnout in absentee ballots. To think that that's going to be growing exponentially, they're just not ready. It's just not possible. So as a practical matter, the states are scared. The volunteers are scared.
Yeah, and of course, they've been pushing universal mail-in balloting for a while, and that is because of this plan that they've been executing for 2 decades now. You vastly increase the registration rolls, and they did that through HOBDA, and requires you to be offered to register when you get your driver's license, or when you get your apply for welfare. And plus other efforts they made. Then they have fought doggedly to prevent the cleaning up of those rolls, and now's the payoff. We'll just send them all a ballot, okay, and then run around, chase those ballots down. I mean, there are statistics like in Las Vegas, there's a homeless shelter where 400 people are registered. In other words, over the last couple of years, 400 people are registered. What's the likelihood that those people are still there? But there's going to be 400 ballots show up, at this Democrat stronghold, no doubt. And I just bet you the vast majority of those somehow or another get voted. So this is the payoff now. We're at the end game, the payoff, where the votes of ballots are set out and then cast. And as soon as they're cast, there's nothing you can do about it, no matter how much fraud you prove. And unfortunately, in the states, I mean, we had a terrible case of voter fraud with absentee ballots in our state, where an election was overturned by the Indiana Supreme Court because of the massive absentee ballot fraud, and that was with fraud protection. And unfortunately, in the few states that have legalized mail-in balloting, there hasn't been the kinds of recounts or contests that can serve to expose the situation, of how are they actually manipulating the situation. We really didn't know in Indiana But the recount involved a Democrat primary in East Chicago, and that's where it is, east of Chicago, Democrat stronghold, where the incumbent mayor, Democrat, was challenged by a reformer, and he stole the election in the primary. There was a recount, and you know, now they're spilling the beans on each other, right? They're now telling us all the techniques that they were using to fraudulently vote people absentee because of this recount. Unfortunately, we haven't had those kind of situations in these other states. But look, we know there's unscrupulous people. We know that they would take advantage to a situation like that, if possible. And there's also an ideological reason. The Democrats believe that every person should be able to vote. They think if you're a kid, they want to lower the voting ages to 16. If you're an illegal immigrant, you should still be able to vote. They have legalized illegal immigrants voting in school board elections in San Francisco. They believe these people should be able to vote. So ideologically, you know, if you say, well, wait a second, there's illegal immigrants on these voter rolls because you've issued them a driver's license and they can then register to vote, you know, we consider that a problem because it should be limited only to citizens. They don't think it's a problem. In fact, that's where they want to go. They want illegal aliens to be able to vote in our election. So it's not just the unscrupulous. It's also an ideological jihad against our restrictions on our anti-fraud restrictions on and provisions to protect voting that they actually ideologically oppose because it prevents people like illegal aliens from voting in our election.
And, you know, I'll speak really quickly about a couple more practical considerations here that no one who's pushing for universal vote by mail seems really willing or eager to confront. One is the fact that sending ballots out in the mail poses some very significant chain of custody concerns. If you look at Election Assistance Commission data, which is not comprehensive, but it covers most of the country, in 2018 alone, 10.4 million ballots went out and no one heard from them again. Now, we don't know what that means. They're just listed as unknown, but they could have arrived at a voter's house and the voter just decided not to vote, which is his or her right, but they could also have been lost by the Postal Service. That's a very significant concern that we have to be able to confront. How do you address the fact that an unprecedented number of ballots would be going out through the US Postal Service, and the Postal Service does not have a really good way of tracking all of those ballots so that you can say with certainty, you know, was a ballot properly delivered? Was it lost? We saw in Wisconsin that ballots were routed to the wrong place, and that raises some significant concerns if you're a voter waiting for your absentee ballot to be sent to you right up until election day and it never arrives. You know, there's disenfranchisement concerns there. Another thing that we can see from election assistance data is how many ballots are returned as undeliverable. And again, in 2018 alone, over 500,000 ballots were returned as undeliverable. That means that the ballots were sent out to an address that could not actually be mailed to. And that raises some concerns again about the accuracy of voter lists. And this is just from the people in 2018 who requested absentee ballots. So you can imagine if we're sending ballots to every single listed voter registration, when the Pew Center for the State's researchers say that 1 in 8 registrations is inaccurate or out of date, you're looking at potentially millions of ballots going to the wrong address, going out in the names of ineligible or deceased voters. That also raises significant concerns. And one other major problem is the fact that first-time absentee voters make mistakes in the casting of their ballots at a rate which is more than 8 times that of people who consistently vote absentee using data just from the 2016 election. So again, this is going to be an election in which, for the first time, millions of Americans are going to be voting absentee, and in an all-mail election, tens of millions of Americans voting by mail. there is significant concern here that ballots could be returned incomplete, wrongly filled out, that ballots, the ballot envelope could not be properly sealed. There are lots of concerns here that have to be considered. And then, of course, you know, when you consider what happens when those ballots are returned in a hypothetical all-mail election, you're looking at the prospect of massive litigation on election day over how these improper ballots are counted, should they be counted. We see this time and again in Florida, for instance, where lawyers will parachute in and will start suing to try to change the counting procedures and processes on the day of an election, get courts to take over and rewrite election law on the fly. And all of that is about seeking a partisan advantage in the counting of ballots. And so, you know, here at a national level, you can expect to see litigation anywhere there is a close race, anywhere where the results are tight, where they think that they can maybe flip a state or flip the presidential election. And that, if that is the way that this is decided after weeks of contentious partisan litigation, that's going to raise serious doubts in the mind of voters about who actually selected their president, who selected their members of Congress. Was it them, the voters, or was it lawyers in a courtroom?
So along those lines, I really liked Catherine's points that, you know, although public opinion polls might indicate that some people find, you know, mail-in voting convenient or think that it will be, those people often don't think through these logistics that Jason just described. And we have quite a few questions here that are kind of get to that process. One of the audience questions is, are mail-in ballots able to be verified that a person who signed the ballot is really the person if voter signatures are not on file? What is to prohibit quote-unquote dumpster diving for ballots?
Yeah, well, a lot of states require, you know, the outside envelope to be signed by the voter, and then requires that signature to be compared with the signature on the voter registration rolls. So if there is not a signature on that, then under the law, that ballot is not cast, all right, and is set aside. Now, of course, the Democrats are already bringing suit against that requirement, and you believe it's unconstitutional to set that ballot aside. So you can, if they haven't brought that suit before the election, as Jason was just pointing out, you can be assured that if you have a close election, and very many of these, they're going to be suing it then to try to get those ballots to be counted. Second type of requirement that addresses the question is a witness. That is, and this is a really important safeguard that exists in, I think, 11 states, and that is you have to have a witness when you actually fill out the ballot, put it in the envelope, and then sign it, all right? And then the witness signs as a witness to the fact that the voter is the one that actually filled out the ballot, and the voter is the person who signed, put it in the envelope and signed the ballot. So that's an additional level of protection that you know, prevents, and of course penalties of perjury and all sorts of things apply in those cases. So that's another protection. You know, and I think we should go a step further. Kansas, for instance, I mean, if we're going to have more than absentee balloting under relatively rare circumstances, if we're just going to open this up, another thing we could do, as Kansas did, is require first that when you register, you have to present a voter an ID, a picture ID. And then if you vote by mail through the absentee ballot process, is that when you send it back in, you've got to take another copy of your voter ID, your driver's license, and include it with the mail-in ballot. I mean, if you add that, it's going to make it much harder, you know, for some third party to cast the ballot. I mean, now they got to get a hold of the driver's license of the actual voter to do that. So, I mean, you know, so that would be another example of something that would be a very good procedure for a state to adopt.
And one of the questions we have here, you might have already answered this, but if there's anything else to speak to this process, is are concerns about the use of voter rolls mitigated by the checks used on the back end of the process when states review submitted ballots?
Go ahead, Jason. You want to address that?
Well, I don't have a lot of confidence at this point, because again, we're seeing lawsuits being filed to try to remove those sorts of protections. So in Nevada, for instance, one of the provisions or one of the complaints points is that rejecting ballots on the back end for signature mismatch, for instance, ought to be stopped, ought to be halted. In that kind of an environment, theoretically, any absentee ballot that is received would then ultimately be counted. So you see on the front end of the process and on the back end of the process, you see concerted attacks on election integrity protections. And we also have to be considering the fact that if we do go to an all-mail election, a vote-by-mail election, in which millions of voters are going to be receiving ballots who have never voted absentee before, I'm not sure logistically how states will work through making sure that they have the proper signatures on file for everyone, including, for instance, first-time voters. I do agree with Jim that there needs to be a concerted attempt on the part of states to think through these sorts of concerns and ensure that there are voter identification requirements in the registration and absentee voting process. And some states do that with the requirement of giving a copy of an ID, sometimes with the ballot itself, or listing a driver's license number or a social security number on the ballot envelope as a second means of ensuring alongside the signature that the person is who they say they are. But all of these protective processes are under attack, and so depending on how those lawsuits play out over the next few months, they may provide a reasonable measure of protection, or they may provide no protection at all.
And I don't know whether the application to apply for an absentee ballot is at the beginning or the end. Maybe it's in the middle. But it is a critical element, I think, of this in this whole thing, because then you have a contemporaneous statement, in many cases, many states, sworn statement, that the person is who they are, that this is where they live, that this is, why they want to vote by mail, and you have all sorts of safeguards built around that. And that's the reason. I mean, that is the most important reason that they want to mail ballots to everybody, is that they want to eliminate the application so that everybody gets it, and all the fraud protections that surround that absentee ballot process are all jettisoned in one fail swoop. And in my opinion, that eliminates about 50% of the fraud protections in the scheme.
So we have time for one last question. Have you looked at disenfranchisement of overseas military voters? If one is stationed in the UK, it takes 2 to 3 weeks for mail each way. It could take up to 6 weeks or more to get a ballot in return, thus missing the deadline for voting.
There's organizations that are dedicated to that to fixing that problem and dealing with it. I have not, and Catherine will have to speak, and Jason, to what True the Vote or Honest Elections has done on that.
We have not taken that. Yeah.
Oh no, go ahead.
We haven't taken on those types of cases, but it is certainly an accurate statement that and there are different laws governing how you can, in some instances, send the ballot online, but it has to be returned via mail. And the inherent protections around all of that, and certainly the time delay, do disenfranchise those voters, and it should be looked into. But as we've described on this call today, this is a 1,000-front war, and right now the greatest threat is with the universal mail-in and all of the attendant ornaments on that Christmas tree that they're trying to hang. This is the end game, and we need to stand shoulder to shoulder to push back on this.
So any final thoughts from our panelists in the next, we have 10 minutes left.
Yeah, the final thing I would say on the military voting is, you know, as much as Democrats talk about disenfranchisement, in the Florida recount in Bush v. Gore, they sent out to all of their lawyers instructions in every single county when the votes were being cast to contest every single military ballot that was being sought to be counted in every precinct, in every county in the state of Florida, to stop every single military person from voting. So that's what they think about the right to vote and disenfranchisement. And that tells you everything you need to know about how this is a gross partisan effort to get a huge partisan advantage by eliminating fraud protections. And they expect to win elections forever once they get, they can eliminate those fraud protections.
More generally, any final thoughts from the panelists?
Well, I'll say that it's pretty clear at this point that there are going to be some significant complications that the pandemic presents to how we conduct elections. But I think that the biggest challenge and the biggest risk to the integrity of the voting process itself that the virus poses is not really the virus itself, but it's how we respond to it. If through some combination of concern over health, which is a valid thing, or this partisan effort to manipulate elections, we wind up swinging the pendulum so far and on a permanent basis in the direction of a vote-by-mail system, which is inherently insecure and which poses the logistical problems that we've outlined and which could, in a very real sense, impact the voting rights of millions of people in a negative way. You know, we're looking at a massive self-inflicted wound on our democracy. You know, we're looking at inviting voter confusion. We're looking at inviting chaos. We're looking at massive litigation that will you know, crop up essentially anywhere where the election outcome could be swayed by that litigation. What we need to be thinking about as we're figuring out how to accommodate this public health crisis is what we can do to make the necessary changes, but to make them in a way where you're making them as tailored as possible. You're making them temporary. You're making the fewest number of changes because we are 6 months away from the election. And you know, the more that you change, the more opportunities there are for things to go wrong. So we need to be adaptable, but we need to be smart about how we do this. And we need to make the smallest number of changes necessary to accommodate voting in this crisis. And we need states to be in the lead here because they have the experience to be running elections. They've dealt with crises, they've dealt with natural disasters, even terrorist attacks, right up to and during elections. We need that experience in the driver's seat here. We don't need mandates from Congress, and we certainly don't need this political opportunism that we're seeing. I think that the consequences, if we go down this road to our democracy, will long outlive the COVID crisis itself. And I think that future generations will look back and wonder why it is that we did this.
Anything else? I think we're about out of time here. Thank you for joining us. Everyone here is doing really great work, really important work. And I can't wait to see, you know, where this goes for the next couple of months. Jason, you said the amicus deadline for the Arizona case, when is that?
I believe that's May 27th. It could be the 26th or the 27th, but it's right around then.
Okay, I know there are quite a few attorneys in the call, so I thought I would point that out. Okay, thank you to everyone for joining us. And I am now ending the panel. Thank you.